Hello and welcome to Lecture 5A on the nature of international investment law. This is actually the 51st lecture of the lecture series on international investment law. But according to the structure of this lecture series, it is Lecture 5A, as this lecture deals with the nature of international investment law and how the subject compares with other fields of law. Before going into the subject, it would be useful to give an overview of certain basic features of international investment treaties and international investment law. Investment treaties, bilateral and multilateral, protect foreign investment into the host country. Investment treaties are concluded between states. Such treaties provide substantive rights to foreign investors in the host state, such as the most favored nation treatment, national treatment, right to effective compensation on expropriation, etc. Most treaties provide for state-to-state dispute resolution mechanism as well. In addition, and more importantly, they usually provide for dispute resolution mechanisms between an investor and the host state under the treaty. In the process of examining treaty violations, arbitral tribunals reviewed state action including in several arenas, including water services, cultural heritage, environment protection, human rights and public health. Given the central features of international investment law, we would now embark on classifying the subject and also comparing it with other related areas of law. For this lecture, we will rely on Valentina Vadi's book chapter, whose complete reference is provided in the description to this video. It is open access and you could read it at your convenience. Now, as regards the most useful feature of international investment arbitration, allowing investors to invoke the investment treaties dispute resolution provisions, Valentina Vadi argues, the internationalization of investment disputes has been conceived as an important valve for guaranteeing a neutral forum and depoliticizing investment disputes. Given that international investment law's primary instrument is bilateral and also multilateral treaties between states, it is classified as a part of public international law. Specifically, public international law governing foreign direct investments. Such treaties include bilateral investment treaties, regional treaties, multilateral investment treaties, free trade agreements and sectoral agreements with investment provisions. There is no international investment court and therefore investors invoke the arbitration related provisions in the investment treaties against the host state. This has led to scholars drawing parallels between international investment treaties and international commercial arbitration. Likewise, there are several features of international investment law that closely resemble those of WTO law, public law, etc. Vadi observes, these analogies are heuristic models used to better understand international investment law and arbitration and to make sense of the related available knowledge. These analogies are descriptive in nature and reflect and emphasize some aspects of the system rather than others. However, far from having a purely theoretical character, the selection of the appropriate analogy is a struggle for the soul of international investment law. International investment dispute resolution has features similar to commercial arbitration involving a state party. Just like commercial arbitration, party autonomy takes center stage where the tribunal is constituted by parties or by the relevant arbitral institutions and hearings are usually confidential. The procedure of both types of arbitration are similar and the awards are usually enforceable under the New York Convention. There are narrow grounds for challenging or refusal for enforcing such awards. Often in practice, lawyers and law students get confused between investor-state arbitrations in international investment law and international commercial arbitrations, where one of the parties is a state or state entity. But there are many differences. commercial arbitration emanates from a contract while investment arbitration emanates from a treaty. The outcome of investment arbitrations directly affect the sovereign power of the state, while the outcomes in commercial arbitrations do not go to that extent. Both international investment law and public law deal with protection and security and non-discrimination. At the same time, both are different in terms of dispute resolution, as international investment law is akin to private commercial arbitration. Just because IIL is akin to judicial review does not mean that it is judicial review. The range of remedies are narrower in IIL. By equalizing IIL with public law, one would run the risk of ignoring the manner in which various concepts of international law has evolved into international investment law. However, given the recent involvement of amicus briefs in international investment arbitrations and limitations on regulatory power of the state, there are many similarities between international investment law and public law. Given these similarities and dissimilarities, scholars have compared the IIL regime with that of the WTO regime, in that both are a part of public international law and have systematic dispute resolution procedures, and the private dispute resolution is simply seen as an aberration, that is, private enforcement of a public right similar to human rights enforcement. In fact, both WTO law and international investment law tend to guard against protectionism. MFN and NT, that is, most favored nation and national treatment, are found in both WTO jurisprudence and international investment law. But as we have dealt with in lecture 31 of the lecture series, IIL jurisprudence has significantly moved from WTO jurisprudence, especially as regards national treatment. Link to lecture 31 is provided in the description to this video. Awards that capture this divergence include Occidental vs. Ecuador and Methenax Award. Likewise, parallels and intersections have been drawn between international investment law and human rights, especially from the perspective that those who are affected can approach courts or tribunals directly. All said and done, in public international law, sovereign power is limited through treaties through consent. So is international investment law. Thanks for listening in. Take care and all the best.